Welcome to today's Explainer. At first glance, a legal dispute over bathroom fittings in Delhi might sound, well, kind of like a hyper-local business spat. But what if I told you that this exact case might literally rewrite the rules of the entire internet? Today, we're looking at a totally fascinating conflict, Hindware versus Google. It's a massive battle over who controls digital traffic, who actually owns your attention, and fundamentally, whether the giant tech platforms we use every single day are truly as neutral as they claim to be. Okay, let's dive right into this. For years, Google has told courts all around the world a very simple, very consistent story. Hey, we're just the messenger. Their whole stance has basically been that a user searches, an advertiser bids, an ad appears, and Google merely connects the two. Right? But a courtroom in Delhi just asked a pretty dangerous question. What if the messenger isn't just delivering the mail? What if the messenger is actually running the whole marketplace? With that single challenge to a decades-old defense, one of the most significant legal battles in India's digital history just completely unfolded.
Section 1. The Invisible Advertising Machine.
To really understand how we got here, we've got to look at the brand at the center of it all. Hindware spent decades, and I mean thousands of crores, building a reputation so trusted it practically guaranteed search traffic. It was a sure thing. But every time a user searched their name, it triggered Google's multi-billion-dollar advertising machine. In just milliseconds, literally the blink of an eye, an invisible, highly sophisticated auction takes place. Advertisers are competing in real time. And then, based on their bids and relevance scores, boom, ads are placed right at the very top of the user's search results. Now, the big issue here wasn't that competitors were just buying generic terms like wash basins. No, according to Hindware, their rivals were actively bidding on the exact trademarked keyword, Hindware. Every single time a competitor bid on that specific word, Google's advertising engine happily accepted the bid. Competing ads were displayed, users clicked them, and all those sales opportunities just shifted completely away from Hindware. And through the entire process, Google collected the revenue. So to Hindware, this wasn't just fair competition, it was direct, blatant exploitation of their hard-earned trademark.
Section 2. The Safe Harbor Defense.
So what did Google say? Their response was pretty straightforward. They invoked Section 79 of India's Information Technology Act. You might know this as Safe Harbor. They argued, look, we're merely a neutral technological bridge between advertisers and users. We don't create the trademarks, and we definitely don't create the ads. Think of the internet as this massive, sprawling highway, and tech platforms are simply the roads. If a driver decides to carry something illegal in their trunk, you don't sue the asphalt, right? Google believed this exact protection applied to them because, ultimately, the advertisers chose the keywords, not the search engine. Section 3, Behind the Digital Curtain. But the Delhi High Court wasn't buying it. They decided to look right past that whole highway analogy. They asked a totally transformative question. If Google is truly just a neutral intermediary, why on earth are they so deeply involved? And this brilliantly illustrates what they found. When the court dug into the actual mechanics of the ecosystem, they uncovered a system that actively provides keyword suggestions, manages these complex real-time advertising auctions, dictates the final ranking outcomes, and of course, takes a cut of the revenue. The more they looked at it, the more impossible it became to view Google as just a passive observer. They weren't just laying down pavement, they were actively directing the traffic, handing out the maps, and taking a toll from every single driver that passed through.
Section 4. The Invisible Trademark Debate.
Which brings us to a really fascinating, completely unprecedented legal hurdle here. Can something that is entirely invisible to the consumer actually infringe a trademark? Historically, trademark law has always focused on visible use. A logo on a physical package or a big neon sign in a store window. But digital trademarks operate in a totally different reality. The word Hindware was often completely invisible to the users typing it into the search bar. It lived solely in the back end, hidden deep inside Google's advertising system as a trigger. Earlier courts had really struggled with this concept, basically assuming that if a consumer never visually saw the trademark used by a competitor, it just couldn't be an infringement. But the Delhi High Court's rationale was groundbreaking. They declared that the trademark was performing a commercial function. They recognized that in today's world, a trademark's value is absolutely no longer limited to what consumers can physically look at. Its true value lies in what it triggers, what it influences, and exactly where it sends consumer attention. Because the invisible use of that trademark was actively redirecting consumers who were explicitly searching for Hindware and exploiting the brand's goodwill, the court said the economic impact was incredibly real.
that invisible exploitation, even hidden in the back end, was more than enough to constitute actual infringement.
Section 5. A historic paradigm shift.
The court fundamentally broke from all those past precedents of assumed platform neutrality. They ruled in favor of Hindware, ordering Google to stop auctioning the trademark entirely. And this matters for the future of the digital economy for 3 massive reasons. First, invisible keyword use is now officially recognized as infringement. Invisibility does not eliminate liability. Second, those traditional safe harbor protections that tech companies have leaned on for years, they're significantly narrowed now. And third, courts have a completely new standard to work with. Moving forward, they won't just ask if a platform hosted content. They're going to ask how actively involved that platform was in facilitating, influencing, and profiting from it.
Which brings us to our final thought for today's explainer. It really comes down to this. If you build the incredibly complex system, if you manage the real-time auction, if you control the entire marketplace, and if you profit from every single transaction, can you really still call yourself just a messenger? It's a profound question, and how we answer it is going to shape our digital world for years to come. Thanks so much for joining me on this deep dive.